Professor Cutler, appreciate you joining me today. I guess, first and foremost, kind of speak about, this obviously executive order that Kathy Hochul has enacted. How often do we see governors enact executive orders like the one she enacted?
Yeah, it's a common practice that governors have that constitutional authority, Sam, to issue executive orders. They can do so for many and sundry purposes, just as the President of the United States, President Trump, has issued numerous executive orders. The governor hasn't gone to the extent that the President has, especially in his first 60 days. But Governor Hochul does have that constitutional and legislative authority, and very definitely she did so under exigent circumstances. We're talking about the Executive Order 47.3, which in fact directs state agencies not to hire any officers who participated in the state prison strikes. And she instructed her Department of Corrections and Community Supervision at stocks to, in fact, report them.
Now, I was just going to say, for those at home who aren't too familiar with, how a public employee could be barred from participating in other state organizations, kind of speak about where she gets that from. Is there a certain law, a Taylor law?
Sure. Yeah, okay. So it is the Taylor law. And the Taylor law specifically prevents individuals in vital public service positions, such as, in this instance, our correction officers in these state facilities, from striking. They were well aware of it. They were giving warnings not to strike, Sam. They decided, and there was a state Supreme Court injunction as well, state Supreme Court order, telling them they cannot go out on strike. The officers knew specifically what they were doing and the circumstances under which they undertook that strike action. Now, I'm not going to comment on the merits of their concerns, because there have been a lot of legitimate statements made, even, in fact, provided by the commissioner, that public safety conditions were not up to maximum standard for the officers in each one of these facilities. And they were very much concerned about their personal safety. The fact still remains, under the Taylor law, they are not permitted to strike. The governor had to call out, pursuant to this executive order, the State National Guard to maintain public service and safety in each one of the state institutions while the officers were striking. So, as a result, she issues this order, and the order says, you cannot come back to work. The positive, if there is a positive, is that it is not a blanket order. Each one of the cases will be reviewed individually, although a vast number of these correction officers will not, in fact, have future state employment.
Now, I know you obviously won't get into the merits of everything, just in terms of the legality. In terms of precedent, do we know the last time that we've seen an executive order citing the Taylor law? I know obviously you mentioned that the executive orders by governors are used, a bunch, but in terms of the Taylor law.
Well, any time you have public employees that, in fact, could be police, it could be fire. We've had sanitation workers go out. There are specific examples that have, over the course of the past several decades, been introduced by governors, and certainly these individuals who were so involved illegally have to pay the consequence as a result. What is unique about this case, as far as I can recall, and I may not be perfect on this, so bear with me, there is a provision in her executive order which, in fact, and there's where I have a problem, she's specifically prohibiting local governments, counties, municipalities, from hiring any of these officers. What she's doing, Sam, is she is suspending local laws, Article 3, 7, Section 450 of county law, and Articles 2, 3, and 4 of municipal home rule law, preventing local governments from, in any way, shape, or form, hiring these individuals who may be eligible for employment in local facilities, such as Sheriff Apple even commented, the sheriff of Albany County, that in fact he was short-staffed and he could use some of these individuals. So I think that's taking it a bit too far legally, and several counties, including Rensselaer County, have already brought suit. I think Chemung County, Oneida County, I'm not sure of others, but there probably are, who will bring suit against the state for this extended action.
So basically, previously we have seen Taylor law be used. This specific case, the local government element of it is makes this one a little different, I guess more unique compared to the other ones. Is that what you're trying to...
Exactly.
Okay.
Well, I can see the rationale, legal rationale, okay, for her suggesting, under the circumstances, where these officers were forewarned, they knew of the law, they understood the law, and they knew of the consequences, they, in fact, should be sanctioned. To the extent that you're sanctioning them from cutting them off for any future career in law enforcement at a county level, municipal level, in other jurisdictions of the state, I think is just not only unwise, I think it's inequitable.
So do these other counties that you mentioned that are, I guess, bringing out these suits, when they go to court, what's their argument gonna look like?
Under the circumstances that the governor overreacted and, in fact, suspended home charter rule. I mean, their home rule is through a charter, and the charter is their constitution. So that's self-rule. And what she's doing is saying, no, you can't self-govern. You can't make these decisions. I'm making the decision for you because I'm suspending your constitution, your home rule provisions, and your local legislation. That's in the executive order.
Now, we've seen sometimes in the past where federal government will say, we're federal government, so our rules supersede the states, or the states supersede the local level. How do you expect that argument, if the state makes that kind of argument, how is that going to be taken into court?
Well, the judges will have to make that decision. You are right that indeed, under certain circumstances, federal law, supersedes state law. But then again, we also have concurrent jurisdiction where the state and the federal government have joint authority. And for certain purposes, we have state, under the 10th Amendment of the Constitution, state supremacy. So states may, in fact, enact laws impacting upon us as state citizens, which may indeed be protected despite the fact that we have a federal government and federal legislation as well. Constitutionally, as long as that's permissible under Article 6 of the Constitution, the Supremacy Clause, states may still enact laws that are indeed valid.
So there are times, again, when the local laws will almost supersede there are times when those exceptions are made?
Well, the local law is through local ordinances and local home rule charter. It's like a constitution, all right? And what that means is that for purposes of local health, safety, and welfare, the local government should be permitted to act. So that's the mayor and the city council, or the city manager, or the county legislature and county executive. So we would have that in the case of Albany County. Albany County's county exec, Albany County legislature, Albany Mayor Sheehan, and Albany Common Council. They're given standby authority to enact laws that impact upon us as citizens of the city, Albany, and or the county, Albany County. State steps aside. State permits that. However, in this particular instance, what Kathy Hochul is saying, for purposes of hiring individuals for, quote, public safety functions, you can't hire any of those, let's say 2,000, all right? We're not going to let you do that. even if your local charter, your constitution, and your local laws permit you to do so. I'm suspending it.
And that's
You see what I'm saying?
Does she have the authority to do that? Is that the question?
That's
the question
correct.
that the
That's
courts are gonna have
correct. And she is suggesting, no, I have the authority to supersede you because of the exigent circumstances upon which they created this situation in the state correction facilities. Therefore, they should be properly sanctioned. That means punished from withholding any employment, not only from the state of New York, but any of the counties, all of our counties, and in all of our municipalities in the state of New York. These individuals are blackballed. They cannot get a job.
So you mentioned obviously what the courts are going to have to decide upon. Whichever way this goes, what are some of the implications that a case like this, that these suits are brought up? What kind of implications can we see in the future?
Well, hopefully we don't have this kind of situation in the future, wherein you are seeing a governor responding properly, as I suggested, with respect to the Taylor law at the state level, but certainly not over responding with respect to the implications for local governments. That's my concern.
So if the courts were to rule in the favor of the state.
Well, whatever the courts suggest, and it may wind up in finality with respect to the Court of Appeals of the state of New York, and potentially, if there's a constitutional question beyond the state, a due process question that arises under the U.S. Constitution, this could potentially even become a federal case, Sam, and wind up in the federal courts, because they're denied the right of gainful employment, separate and apart from their former employment with the state, future gainful employment. And that may raise some constitutional questions extending beyond state constitutional issues and state legislative issues.
Because their employment's it's the employment part that can raise the federally.
Yeah.
So yeah, I mean,
right to meaningful employment, gainful employment. Yeah.
Very interesting. And obviously, seems like lots of considerations, I guess, that the court's going to have to look into. And I know you spoke about the Taylor law. Are there any other kind of laws, maybe you touched on it a little bit just now, that I guess the courts are going to have to take a look at besides this Taylor law?
I'm not quite sure what you mean in terms of other laws. There are lots of laws in the state of New York. I want to see from your perspective, like if you're on the court, like are there any other laws that can be brought up besides the Taylor law in this case? Well, that's the law at issue, and then specifically you have local laws permitting the hiring, and you have state law. I think she's citing civil service law because CSEA is impacted, right? So you have civil service laws that are being impacted as well. In addition to all of local legislation that's being superseded, so that's being impacted. That's what I'm saying. I gave you the references to the county laws and the municipal laws. All of that will be taken into consideration in the litigation that's been brought against the state of New York.
So the county laws and municipal laws too.
They will be addressed, absolutely.
So in cases like this too, in terms of a timeline, I know it's not always easy to forecast the kind of the timeline, but I guess from your perspective, looking at past cases that may have dealt with this, what's the expected timeline on this case?
Well, I would hope it would be expedited. Okay, so it goes into state supreme, and then it goes to appellate division, and eventually it would wind up in the highest court, which is the New York State Court of Appeals.
And then the other question too is, while this whole thing is being litigated, are those employees going to be barred from these state agencies in that meantime? And is that another?
Well, okay. So what they're going to seek is, in fact, I mean, the 2,000 or so workers, and they may bring a separate class action suit against the governor. They will try to stay any order which says they cannot go back to work. That would be a temporary injunction that they would seek to prevent them from having any source of income or health insurance for their families. I don't know that that will be effective. I think that the individuals that we're talking about, if they bring suit, the one I'm talking about specifically is the suit from the counties, all right? But those individuals who have been fired and permanently barred may bring separate suit against the state, against the governor. And in those circumstances, the state Supreme Court judge will have to make a determination as to whether they're entitled to anything while this litigation is going forward.
This is going to be state. You said state court right now. When would it get to that point when federal court potentially may play a role into this?
Okay, so we go through the state triangular system: Supreme Court, Appellate Court, Court of Appeals. Once the Court of Appeals has rendered its decision, if there is a federal constitutional issue, Taylor law is state, okay? But if there's a due process issue, the right to future employment, then in fact the federal courts, excuse me, can become involved. Federal District Court, Federal Appellate Court, and U.S. Supreme Court.
Wow, so due process really plays a role into this if they, you look into that.
And that's not a snap of the finger. That's not just a few months. This could certainly drag out over a period of time if it's rising to the level of federal jurisdiction.
So we're talking about years, maybe.
Well, it could be 2 to 3 years, yes, potentially, and costly. But the unions would have to provide support for their former employees for legal purposes,
And what's the and obviously it could be those 2 or 3 years. Any likelihood on them reaching some kind of settlement early on? Have we seen this in previous cases at all?
I don't think this governor is prepared to compromise.
No.
I don't see that happening. She's pretty much dug in. I could be wrong, but she appears to be pretty dug in. We'll see what happens in the lower courts and how the courts rule as to whether or not she changes her position at all. But at this point in time, I don't see that happening.
Now, her term is up in a couple, theoretically, if she were to, no longer be governor, there's another governor, could they theoretically just drop the entire case, or how would that work?
At some point, yeah, if she's not reelected, if the litigation is still going forward, lots of things could happen. That's a big if question, okay?
Yeah.
We're nowhere near there yet.
And
I think certainly before the election, this case, the one we're talking about with the Taylor law and the future employment in the counties, that will be resolved before her reelection.
I guess the other question too, obviously, this is her executive order, and you spoke about the federal courts potentially getting involved. Is there any way the federal government, is there any way Donald Trump could get involved in a case like this?
Could informally. Presidents always have that federal power of persuasion, if you will. I mean, New York State relies pretty extensively and expansively on federal largesse, and the governor was just meeting with President Trump in the past couple of weeks, as a matter of fact, in Washington. And he talked about issues of mutual concern. The president, former New Yorker, was very amenable to the governor's request for massive assistance with respect to refurbishing and redoing Penn Station. That's a major project. It's millions upon millions of dollars. Where's that money going to come from? Well, in substantial part from the federal government. Can the president be persuasive in terms of his approach to the governor if he felt so strongly about interceding or intervening on not only this issue but other issues as well?
He could withhold funds.
He might be able to withhold funds, or he might be able to provide funds. I mean, that's a decision that the president and the various federal agencies make in conjunction with the United States Congress, which has the authority to appropriate the funds, Sam.
So you have the funds there, and then also any executive orders he could also enact, and how would the executive orders at the federal level, how would that correlate or mix in with her executive order?
Oh, yeah. Well, I don't think he's going to issue an executive order that would, in any way, shape, or form, supersede the Taylor Law. That he's not about to do. But yes, he has the power of issuing executive orders that impact on the state of New York and impact upon us as citizens of the state of New York, because we are U.S. citizens as well.